Okay, so let's talk about what a shackled convention is. What is a controlled or shackled convention? It is a convention called by the states according to Article 5 of the Constitution, but supposedly contained by, quote unquote, strongly worded state resolutions that would supposedly be a binding document that would force Congress to pass as part of the resolution calling for the convention, thus shackling the convention to consider only the matters contained in the resolution. To see where the shackles came off the first convention, we have to know where and how they were applied by Congress and the states in the first place. Shackle number 1, the congressional resolution. This is the resolution calling for the Constitutional Convention in Philadelphia. This is obviously not the whole thing, but read this out and look at the part right here at the bottom. Sole and express purpose of revising the Articles of Confederation. There is no doubt what that means. It doesn't mean that they're allowed to chuck it all and write a new constitution. The phrase sole and express purpose of revising the Articles of Confederation simply cannot be misinterpreted. It is difficult to imagine a stronger set of shackles on convention delegates. Congress asked the states to send delegates to the convention. Congress didn't compel them because it had no authority to do so. Rhode Island appointed no delegates to the Constitutional Convention. 10 Amendments for Freedom assumes that because the states were in charge of the first convention, they will also control the next one. There are several reasons why this is a rash assumption. Under the Articles, the Congress could do nothing without the say of the states. The states retained virtual full sovereignty, especially with regard to the structure of the Confederation. There could have been no convention in 1787 without state delegates. It simply could not have been done. Under the current Constitution, the sovereignty of the states has been almost completely eroded by federal usurpation and the passage of the 14th, 16th, and 17th Amendments. 10 Amendments for Freedom's plan assumes that the states will be asked to send delegates to a new convention. There is no reason to assume that Congress will do it this way with a new convention. There is no constitutional requirement that Congress ask the states to form delegations. Here is Article 5. The Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or on the application of the legislatures of 2/3 of the several states shall call a convention for proposing amendments, which in either case shall be valid to all intents and purposes as part of the Constitution when ratified by the legislatures of 3/4 of the several states, or by conventions in 3/4 thereof, as the one or the other mode of ratification may be proposed by Congress. For those who might think the Constitution is a perfect document, this is a ghastly flaw in Article 5. Article 5 was essentially an afterthought at the con, so it was not really thoroughly hashed out. I think they spent like a day, maybe half a day on Article 5. The delegates assumed that state sovereignty would not erode to the point it has today. That implies that they believe states would remain a necessary part of any future convention. Therefore, they didn't write it in. It was one of those things that the assumptions were so strong that it was so obvious they didn't feel they had to write it down. Because of these assumptions, they failed to build proper safeguards into the design of Article 5. Now, because of this, Congress has a free hand to ignore the states completely in the appointment of delegates, or more likely, Congress will allow the states to choose delegates from a list of approved delegates, or with a highly restricted requirements, law school professors, respected jurists, constitutional scholars, etc. Or worst of all, through the appointment of blue ribbon panels. In any case, people who are strict constitutionalists, people like us, have about the same chance of being appointed to a new con as we have of being killed by a meteorite made of white kryptonite. It's not going to happen. Despite the rhetoric from 10 Amendments for Freedom and ALEC, even the most cursory examination of history will show that the unequivocal and very strongly worded resolution from Congress had not the slightest effect on the delegates who, in their very first act, voted to operate in complete secret. Can anybody imagine why that was done? Basically, obviously, it was to protect those who were going to be in complete violation of their charter. Their second act was to vote to completely rewrite the Articles of Confederation in violation of their charter. Remember, only a quorum of states was present and only a few members of some of the state delegations when the convention was gavelled to order. By this time, the early arriving nationalists, those who wanted to eliminate the state governments, had already seized the control of the convention and begun to make the rules. There it is, folks. Those who get there first and have the plan, make the rules. Since the balance of power was with the states in the first CONCON, we need to show that it wasn't just Congress which had issued strongly worded resolutions. All right. So did most of the states, to the chagrin of ALEC and 10 Amendments for Freedom. Here they are, from the New Hampshire CONCON resolution. To discuss, well, let's see, there we go, to discuss and decide upon the most effectual means to remedy the defects of the federal union. Look at Massachusetts. In conformity with the resolution of Congress recommending a convention for the sole purpose of revising the Articles of Confederation. Connecticut, for the sole and express purpose of revising the Articles of Confederation. New York, for the sole and express purpose of revising the Articles of Confederation. New Jersey, for the purpose of taking into consideration the state of the Union as to trade and other important subjects. And this brings up an important matter. The Constitutional Convention was called to fix the trade issue. There was a major problem with interstate trade. That was the real reason the Constitutional Convention got called. That was the underlying excuse. The fact is that the nationalists were using that as the lever to get the convention. Okay. Pennsylvania, to devise such alterations and further provisions as may be necessary to render the federal Constitution, that is, the Articles, fully adequate. Delaware, to devise such alterations and further provisions as may be necessary to render the federal Constitution, same language, but look here. Provided each state in Congress assembled shall have one vote. Delaware so shackled their delegates that they were not allowed to discuss any scheme which would reduce the one state, one vote representation that existed under the Articles of Confederation. They were absolutely forbidden from talking about it. Did that stop them from being involved in this? No, they were operating in secret. No one would ever know. Maryland and Virginia, basically to use the same language, devise such alterations and further provisions to render the federal Constitution, again, the Articles. The North Carolina shackle for the purpose of revising the federal Constitution, the Articles. South Carolina to devise such alterations as may be thought necessary to render the federal Constitution entirely adequate. Georgia, same thing. And Rhode Island said, that's their shackle, they just didn't come. All 12 states are calling for amendments, alterations to the existing Articles of Confederation and the federal union that it creates. All the resolutions are clear and unequivocal on that point. They are all strongly worded. Massachusetts, New York, and Connecticut especially so. Delaware further restricting delegates. Considering the undeniable fact that the states were completely in charge of their states' convention delegates, it is difficult to conceive of a more shackled convention than the one in 1787 in Philadelphia. Yet they completely ignored their charters, both federal and state.